Jordan Walker. I'm an attorney with Seaver Walker Padgett Law Firm. It is time to start this webinar. If you have any questions while I'm presenting, please go ahead and ask them as we go along, and I will address them at the end. And forgive me one sec. Let me get this screen share. Okay. Thank you again for joining us this evening. Again, my name is Jordan Walker. I'm with Seaver Walker Padgett Law Firm. Today, we are here to talk about the SH68 project. We're here to talk about eminent domain and share our experience with you, the landowner, who, according to our research, is affected by this project. If you received one of our letters, it's because, according to our due diligence and according to public record information submitted by the Texas Department of Transportation and property records, your property is one of the properties that is likely going to be affected by this project. So that's why you received the letter. Who we are, Seaver Walker Padgett, we are an eminent domain only, landowner only law firm. This is the only area of practice that our firm does. It's the only area of law that I've ever practiced. Meaning we only do eminent domain and we only represent landowners faced with eminent domain. We have never represented a condemnor, the government, a utility pipeline, you name it. We have never represented those that can take land. We've only represented, and we will only represent landowners affected by this project and this process, I should say. So today our goal is to talk about eminent domain, to share our experience with you, the landowner, so that when the DOT comes in and starts talking about acquiring your land, you are prepared and you can handle it appropriately. Before we get into it, I want to talk about what eminent domain is. Eminent domain is the power of the government, in this instance, to acquire private land and put it to a public use. Meaning, if the government wants your property for a road project, for example, and they follow the law in trying to acquire that land, ultimately, they can take the land, whether the landowner likes it or not, utilizing the court system, utilizing the courts. So what happens is the DOT files a lawsuit to acquire private land and put it to, in this instance, the SH 68 project. So ultimately, what it boils down to is that the DOT, the government, can take your land and put it to a public use, but there are some requirements they need to meet before they can do that. And we'll talk about what the process looks like here in a bit, but just understand that the DOT has the power, like every other DOT, that you see across the country. They have the inherent ability to acquire land and put it to public uses. So this is a power that the DOT has. So the project itself, the Texas SH68 road project is a road realignment. So as you can see the map here over to the right, this the project is located in Hidalgo County, and you can see this red line right here represents the preferred alignment of the project. So they are realigning SH68 to go east of McAllen, Edinburgh here, and then meet up with Texas 2, I-2 down there at the south end. So that's the plan. That's the project. It is a significant project. Quite a few properties are affected by it. There, as you can see, usually when new road is being built, there's quite a few properties, and usually they are not great acquisitions because they are new roadways. They are cutting through properties that are usually not next to large roadways. So in other words, a lot of times new road cuts through properties more awkwardly than they would a widening project, for example. So usually the acquisitions are more impactful, more damaging to the property owners along the way. So this is the project as you can see it. Where we are in the process is the DOT has, we'll call federal approval for this project to get federal funding. So the funding will be available for this project, at least federally. And we expect land acquisition to begin sometime this year and going into next year. So we talked a little bit about that. We talked about what eminent domain is. Again, it's the forced acquisition of your land and to be put to a public purpose or public use. A road is a public use or public purpose. So they can take it, but they still have to pay for it. And as a landowner, even though they can take it, you are entitled to just compensation for your property, which means that ultimately, if you so choose, you can have a jury determine how much you're entitled to. Uh, Getting just compensation further means that it isn't entirely in the hands of the DOT of what you get. They don't get to determine the compensation that you're entitled to. You also don't get to determine the compensation you're entitled to. Ultimately, it could be up to a jury what your compensation is. So because that possibility exists, you have the ability to reject any offers that are issued to you by the DOT. Meaning when they come in and start making offers to you, you do not need to accept them. You do not need to accept. You don't need to make a counteroffer. You are under no requirements. Certainly you do not need to accept the offer that's presented. If you're a landowner who's interested in trying to stop this project or try to stop the acquisition on your property specifically, that is generally a difficult battle. It's one we've done before, but it's a very fact-specific discussion. So if you feel like you are one of those landowners who would like to stop this project from happening altogether or stop the acquisition on your property, feel free to reach out to me after the presentation. So talking about eminent domain, the process in Texas, each state has their own unique condemnation process. And condemnation, I should say, is just another word for eminent domain. So each state has its own unique process and procedure. In Texas, we're going to talk about that process. These are the requirements that the DOT needs to meet in order to file a condemnation petition or a lawsuit. So these are statutory, meaning they have to follow these timelines, these requirements, if they want to acquire the property through eminent domain. So before they can even file, the first thing they need to provide to a landowner, and this is a schedule on the most aggressive schedule possible. So you see the day 1, day 24, day 31. These are the minimum time requirements that need to pass according to statute. So the written final offer, for example, needs to take place at least 30 days after the initial offer, which could be on 31. It could also be on day 61 or day 71. But these are the minimum time requirements because I wanted to provide what could be potentially the fastest your case could go through the system. So if you, on day 1, you receive an offer. So that, let's say you get an offer tomorrow. The offer will be issued. It's usually in writing, but it doesn't need to be. It'll usually be presented by a right-of-way agent that's working on behalf of the DOT. They'll present it to you, and that'll be that. And then at least 7 days prior to the final offer being issued, in this instance, it would be on day 24, the DOT needs to provide what is called the Landowner Bill of Rights. The Landowner Bill of Rights is a set of requirements, restrictions, rights that landowners enjoy, protections, I should say, protections that landowners enjoy against government overreach and government malfeasance. So the Landowner Bill of Rights sets forth all of the rights that a landowner has in the eminent domain context. They provide basically the laws to the landowner directly. The DOT will need to provide that to you at least 7 days prior to the final offer being issued. The final offer is the written final offer, and it could be issued as soon as 30 days after the initial offer was issued. The written final offer must include the appraisal report that the DOT did to form the basis of the offer that they issue. That offer must be equal to or less than what the appraisal report says. They need to provide a copy of the document they want you to sign that conveys the land, so a deed or an easement. They need to provide a plat map, and again, of course, it must be in writing. Our firm, Seaver Walker Padgett, gets involved as soon as offers are issued. So if you have an initial offer from the DOT, you are ready to hire an attorney, ready to hire counsel. And if you're interested in hiring our firm, it's as simple as giving me a call, and I'm happy to look at any offer you may have, evaluate it, give you my thoughts, and then you can decide what you'd like to do. So you've received the written offer. It's day 31. What happens now? Well, at minimum, 15 days after that written final offer has been issued, day 46 potentially from 45 days after you receive the initial offer, the DOT could file or is allowed to file their condemnation petition. So as soon as potentially 45 days after you received your initial offer, you could be in court. This is all to say that this is a very compressed and aggressive, tight schedule as far as condemnation procedures go. In other states, they usually are not this compressed and aggressive. So it's important that you, when you do receive correspondence, communication from the DOT, that you read it, talk to an attorney, understand what it says, because you could be on a timeline that you're not aware of. So let's say you've gotten to day 46, they filed their lawsuit. They'll file their lawsuit. The judge that oversees the case, it's appointed to the case or assigned to the case rather. The judge appoints a board of commissioners. These are owners, or forgive me, citizens, people that live in the county where the property is located. And their job, upon being appointed by the judge, is to come out and determine their own compensation amount. So what happens is the day 46, the lawsuit's been filed, the commission's been appointed by the judge, and then about a month and a half to 2 months after that, potentially at least 20 days after the board of commissioner has been appointed, a hearing is held before the Board of Commissioners, and their job is to determine at that hearing what the preliminary compensation is that you're entitled to. So, for example, let's say the DOT comes to you, they offer you $50,000. Your case, you reject it, it goes to litigation. The Board of Commissioners is appointed by the judge. They have a hearing on compensation. They hear your evidence on compensation. They hear the DOT's evidence on compensation. They do their own analysis. They determine a preliminary compensation amount, which the DOT can then deposit with the court and then gain access to your property to begin construction. So if you were offered 50, it goes to litigation. The Board of Commissioners says you're entitled to 100. The DOT deposits that 100 with the court, and they begin work on the project on your property. The case is not over, though, or potentially it's not. If either party, yourself included, the landowner, objects to this Board of Commissioner determination, in this instance, it was $100,000. If you feel that still isn't appropriate, or if the DOT feels that's way too much, either party can object to that amount of compensation. If neither party objects, then the case is over, and you would, in this instance, get $100,000. If neither party objects, the case is over. If even one party objects, the case continues on, ultimately ending potentially, if it gets that far, to a jury trial to determine final just compensation. So that is the beginning to the end condemnation procedure in Texas. Very abbreviated, of course, but that gives you an idea really of how quick this process can move. So when you start hearing communication, start hearing appraisers coming out, DOT talking about acquiring your land, that is when you're going to want to talk to an attorney, so you're prepared so that you don't get overwhelmed by this pretty quick condemnation procedure. With that being said, what to do when you get an offer? As soon as you receive that initial offer, first of all, insist that the right-of-way agent communicate with you only via email and make sure they send their offer packet via email as well. This is good for a couple reasons. One, if you have a written correspondence communication with the right-of-way agent, you're always going to have a record of communications. So there's no need to rely on verbal promises being made by the DOT about what they will and what they won't do. Have them communicate via email. So if they're willing to, give you some money, then they can put it in writing and not just say it to you in person or over the phone. Then once you get that offer, say, thanks, I will review this and get back to you in a week. And then the interim time period, you contact an attorney, they evaluate the offer, they tell you what they think, and then you decide what you want to do. Again, avoid in-person discussions and negotiations. They do not benefit you as a landowner. What not to do? Do not jump into negotiations without talking to an attorney. Do not go out and get an appraisal unless instructed to by an attorney. Personally, I tell my folks not to go out and spend that type of money unless they need to. And it isn't always necessary to get an appraisal. So just keep that in mind before you go out and spend that type of money. Do not meet in person with the right-of-way agents or anyone from the DOT. We already talked about that. Don't make a rush decision, but at the same time, don't ignore it altogether. I have folks kind of do one or the other a lot of times. They want to jump in and start negotiating immediately. That's usually not going to end up in a good spot, or they ignore it and they pretend it doesn't happen, out of sight, out of mind, and then all of a sudden they're in court and they don't know what they're doing. Neither of those is an advisable strategy. The strategy that I recommend is as soon as you get an offer, contact me, and I'm happy to look at it for free and give you my thoughts, and you can decide what you want to do. Talking about hiring attorneys, the way our firm works allows landowners to hire us without coming out of pocket, without having to fork over a ton of money to allow us to do our job. We work on a contingency fee basis, meaning we get paid contingent on how well we do for you. A very easy example is if you're offered $10,000 and you hire our firm, we get you $100,000. Our firm takes a third of the 90 that we add to the case, and you get the rest. The resolution comes out at the end, so you don't need to pay me to be your attorney. It's as simple as signing a contract and allowing me to get to work. Our fee comes out at the end. So with that being said, that is the end of my presentation. Moving forward, if you have an offer, that the time to look for an attorney and get an attorney is now. Do not rush into a decision. We talked about that. Remember, this is your only chance. Once the documents are signed, that's it. It's done. It's over. I think it behooves you as a landowner to, at the very least, get a second opinion on what they think about this case, what they think about your case. Even if you call me up and I say, this is as good as it's going to get, I just take it and move on. At the very least, you're getting a second opinion. You're getting some insight from some people that might have some experience dealing with these cases. So that's what I would do if I was affected by eminent domain. That's what I recommend you, the landowner, do as well. That is it for me. If you have questions or comments, feel free you can text me at this number or call me at this number, the 470 number. You can also call us at the 737 number. Honestly, if you call any number on our website and just ask for me, Jordan Walker, they should be able to connect you. And then finally, that is my email address. If you'd like to send me any questions via email, that's probably the easiest and the quickest way to get in touch with me. Okay. All right. That is the end of my presentation. Thank you so much for stopping by. I appreciate you being here tonight. Good luck, and feel free to contact with any questions you might have.